Welcome back, everyone. In today's case, we have Ronald Lamar Allen standing before the court, charged with a terroristic threat involving a public servant and placing the public in fear of bodily injury. The stakes are high, a third-degree felony with punishment ranging from 2 to 10 years in prison, plus a hefty fine. Stay with us as we break down the twists and turns of this case. Will Mr. Allen receive leniency, or will he face the full consequences of his actions? Let's dive right in.
Allen? All right, can I get a file stamp, please? No problem. Court is calling 2025 CR 00756.
Right off the bat, we see Mr. Allen's legal team confirming they've received and reviewed all discovery documents. This is a key moment, ensuring that both parties are on the same page before diving into the plea. In a criminal trial, these documents contain vital information, and the defense must confirm they understand everything. The court is moving smoothly so far, but let's see what happens next.
For deferred adjudication or community supervision with your attorney?
Yes, I did.
Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes, I did.
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Allen, did you review the court admonishments and waivers with your attorney?
I did.
Did you understand it and sign it in all the appropriate places?
I did. I did.
All right, you're charged with a terroristic threat.
Now the judge walks Allen through the possible consequences of his plea. This is an intense part of the process. He's not just facing prison time, but also a fine. And if his plea is rejected, the judge makes it clear it could mean even harsher consequences. The legal stakes couldn't be higher. Are you surprised by the seriousness of this charge, or is this what you expected in a case involving public safety?
The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea you were giving up those rights?
I do.
Did you intend to give up those rights and enter into a plea in this case?
I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
Here we see the plea agreement being outlined. Ronald Allen is agreeing to community supervision instead of prison time, although the judge makes it clear that this is no guarantee. The state is silent on the matter of deferred adjudication, but the judge could still surprise everyone with a harsher ruling. How would you feel entering a plea like this, with your future hanging in the balance? Let's see how this plays out.
Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
Date?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
And counsel, I believe.
This is where things get technical. The judge explains the waiver of appeal, a legal formality that prevents Allen from challenging certain aspects of his case once a plea deal is accepted. The plea deal includes a fine community service and no contact with specific individuals. If you're confused about how a plea deal works, this is a critical part to understand. The question now is whether Allen will live up to his end of the bargain, or if the court will impose additional restrictions.
Recommendations.
I understand.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, receipt tenders, what has been marked State's Exhibit 1 and all attachments.
All right. Did you review any objections?
I have no objections to those pieces, Judge.
Mr. Allen, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right. Any objections to the court reviewing? Okay.
Now we're diving into some serious family matters. Holland's desire to maintain supervised access to his son Aiden. The family drama here adds a human element to the case. His legal team emphasizes his commitment to being a father, but the court is balancing legal obligations with personal considerations. This is where the case moves from the purely legal to the deeply personal. Should the court consider family matters so closely? What do you think, viewers?
All right. Yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order. And there's a third person. It appears, well, there are two other people. It appears to be either this is Gallegos and then they have Ramirez. And
As the protective order discussions heat up, confusion arises about who is actually under the protective order. The tension between legal documents and practical realities creates a pivotal moment in the case. Is this a simple misunderstanding, or is there a deeper issue with how this case is being handled? The defense and prosecution are both scrambling to clarify the situation. This is where small legal nuances can have huge consequences.
that's the only way I can read it, because, and the reason why I'm saying that's the only way I can read it is because it lists Medley, it says protective order, and then indented right underneath, it says M. Medley, which is the state has outside the agreement. They're asking for a no contact order with that person, with Charles Ireland. And then they have someone by the name of Gallegos and Ramirez.
Right.
And then right after it says that it has protective order, then right after it mentions those three names, then again, it says 2-year protective order granted as to, I believe that's the mother.
That's the mother's name. Yes, Mrs.
So-
Allen. Yes. But there is no protective order granted in that order regarding Mark Medley, regarding any of those people. The only one that has a protective order granted against is the mother of the child that we're talking about here. Ms. Gallegos is here and she hasn't asked for a protective order. And we know that the amicus doesn't have a protective order either.
Okay, so this is what I'm going to do. I've taken your plea, and if somebody can tender to the court whatever the orders are on the civil side, I'll review those, because those judges' notes that were handed to me appear that there's a no contact order. And I think you want to have those.
Right.
With the judge's notes in hand, the court is revisiting earlier decisions and agreements. The critical moment here is the decision regarding the no contact order. The legal back and forth continues as both sides try to make sense of the protective order's specifics. How would you feel if your fate rested on these fine details? This case shows how even seemingly minor elements can create major consequences.
Have to keep up my educational courses. And then the second week, I have jury duty, and I can't have other people go to jury duty and sacrifice their work, but I'm not willing to do the same. So I have jury duty that week. So it'll have to be the third week in September, and that'll give everybody a chance, and perhaps a chance for you to speak with the state with regards to all the names that they have listed outside the agreement, because they have Medley listed as a no contact person too.
Well, and absolutely. And we understand that Mr. Medley called.
Mr. Allen's attorney makes a final plea for him to attend his father's services, while the court expresses concern about compliance with the order. The judge appears inclined to allow it. It's moments like this where the personal and legal worlds collide. Should a defendant's personal life be weighed more heavily when considering sentencing? This is a delicate issue for any judge to navigate.
That are the attorneys representing each of these litigants.
The best way to discover what that means is
Judge. Yes.
the judge.
I just have one request. We have services for my father September 5th. And I'm on the
Go to the
DPS.
services.
Yes, thank you. Thank you.
Yes.
Absolutely.
But here's the thing about going to those services and state, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order, and I will do the style, and you all need to write down your agreement.
Okay.
All right.
Absolutely. Thank you.
So you're welcome. So Ms. Ferguson,
Yeah.
when can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side,
Yes.
so that
absolutely.
this could a little bit be in harmony.
Absolutely. I agree.
The tension ramps up as the court sets a future date for finalizing sentencing, September 16th. The delay gives both sides time to clarify the civil case details and resolve the discrepancies in the protective order. In the meantime, Ronald Allen's future remains uncertain. Do you think the court's approach is fair, or does it seem like a delay tactic?
Got the record. Ms. Gallegos, if you'll come up. All right. Hello. How are you doing?
Yeah. Good. How are you?
Good seeing you.
Good to see you.
So anyway, it appears the documentation that I've received that has the judge's notes,
Mhm.
the way it's written, it appears that you're a part of the protective order. Bentley is a part of the protective order. So if the court can get clarification from the judge
Okay.
on that side about who is really included in the protective order and what they are doing with the visitation, that will be greatly.
As the attorneys confer with the judge over the final details, we're getting closer to an answer. The questions about the protective order linger, but the civil side must weigh in for a comprehensive ruling. If the case hinges on such small details, it's easy to see why legal battles can get drawn out. Are you on the edge of your seat yet?
Now, to start.
No, I mean,
Okay.
so I'll just need that information before the 16th. So if you all can get the judge to, if you all want to, you can have the judge email me and
Okay.
say, this is who's a part of the protective order. Or if there's a document, can you pass me that sheet of paper? Or if there's a document that tells me this is the part of protective order, because the way the judge's notes are written,
Mhm.
it's so,
Okay.
oh, you know what? I'm sorry. I need to add this.
So normally on the civil side, Mr. Medley is first because he's
Mhm.
the petitioner. Margaret Gallegos, me, I represented the respondent,
Mhm.
and then Anna Ramirez was the amicus.
Yeah, no,
And then it goes down.
The reason why I say that is because in the plea bargain agreement, even though it's outside their plea bargain agreement, Medley is mentioned. I'm sorry, can I have that printout one more time?
After all the back and forth, the case is officially reset, and the defense and prosecution will have to come back for further review. While the decision on sentencing won't be made until mid-September, the legal wrangling is far from over. What's your prediction for how this case will unfold? Will the judge follow through on the plea agreement, or will something unexpected happen?
Would prefer that I know and probation knows.
So on here, it says 2-year protective order granted as to Mrs. Allen.
But above it, it says protective order.
Okay.
So if you all will fill in the dates for him, please, and what you all have agreed on as far as his ability to go to his father's services. So that sheet of paper, if you can just put in the agreed times where he can travel for his father's services.
Okay, I'll do that now.
All right. And if you all will confirm that, and then we will come back. Norma, you said the 16th?
Yes, ma'am.
All right, so we'll come back on September 16th, and at that time, I will enter my order. And we're back on the record, Cindy. And counsel, it's the court's understanding you're waiving PSI and TAP evaluation?
I would.
All right, so thank you.
So there you have it, folks. The case of Ronald Allen is a roller coaster of legal maneuvering, family considerations, and a hefty dose of courtroom drama. As we wait for the final ruling in September, what do you think will happen next? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.